Glad you're all here. It's right at 6 o'clock and it's time for legal issues for homeowners associations. I think we've already gone through the list and I hope that we've been able to call through and make sure that everyone that's here tonight is with a mandatory homeowners association or here because they want to learn more about mandatory homeowner associations. This is not a workshop for voluntary neighborhood associations. You'll get very, very confused. If that's what your association is a voluntary sort of inner city neighborhood that you join if you want to. You don't have, you pay dues if you want to. There's no covenants, never really hasn't ever been any covenants. That's not this type of workshop for that. We have other workshops for those kinds of neighborhoods. My name is Georgie Rasco. I'm the Executive Director of Neighborhood Alliance. I have two other staff members with me here tonight. Ana Herrera-Dangy from who works with mainly the South Side neighborhoods is here as well. And Sarah Lawhead, who is the North Side community organizer, is also with us, joining us tonight. We're very, very excited that all of you are with us tonight as well. Ana has some slides that she's going to start with us tonight. So tonight's class is very full. We have a lot of people, more so than we normally have in this class, and we're going to continue to have more people joining us. So all of the questions in tonight's class are going to be taken through the chat, and we're going to put everybody on mute automatically. So you're not going to be able to ask questions over the speaker. You are going to need to go to your chat. Hopefully everybody knows how to use that. You go to the bottom of your screen, you'll see a chat button and you'll need to type in your question. And I will be feeding those questions then to Matthew at appropriate times through the presentation. Hopefully there'll be enough time for all the questions because our workshop didn't our registration didn't allow for the registrations to be cut off at the time that it was supposed to this time. But we're very glad that all of you are here for HOA Legal Issues Workshop. Okay. Neighborhood Alliance is a 501c3 nonprofit organization. We're 45 years old, and our mission is quite simply to help create safe, beautiful, and healthy neighborhoods for all. Okay. Our impact each year is over 225,000 households that we reach. We have over 600 neighborhood and homeowner associations in the Oklahoma City area alone. We recently, in the fall of 2021, took a contract with the city of Norman and are starting to work with neighborhoods in that area. We train and connect over 3,800 individuals in civic engagement activities each year. We engage over 5,000 volunteer hours in neighborhood cleanups and social services, and we reach over 14,000 households and neighborhood specifics with monthly crime prevention materials as well. Okay. We are a very important part of the city of Oklahoma City and the Oklahoma City Police Department. We have contracts with both of those. However, the only way that we can continue to provide our services to you and to the neighborhoods is by donations that we get from you and your neighborhoods. So typically this class has a minimal charge to it. Matthew Winton, the attorney that speaks for us, does not charge for his services in giving this class. He has done it for 13 years free of charge, and we are grateful for his partnership. And then we have a sponsor, Matthew Bittinger, that we're going to talk to you about in a moment. But the charge that we charge, the nominal fee that we charge for it, helps us pay our almost $750,000 a year budget that we have that keeps our organization running and keeps us and allows us to be there when you have questions about your HOA and allows us to put on the workshops that we have to do. The only way we can keep our doors open is if we can tell our other funders that yes, our clients, the neighborhoods, provide donations to us. If we can tell Kirkpatrick Family Fund or the Oklahoma City Community Foundation grants that yes, last year 83% of the neighborhoods in Oklahoma City donated to our services, then that's a good wish on their part, a good part on them, that they're more than willing probably to give us a donation or a grant. So your donation goes a lot further in us being able to get other foundations to be able to provide services to us. Okay. One of the ways that you can donate for us tonight is you can use the QR code that's on your screen. You can take a picture of it and it will take you directly to our donate page. Just scroll down to where it says donate, and then you can make a donation tonight if you're willing to do that, you or your neighborhood. Okay. And tonight we'll have another opportunity for you to use that QR code at the end of the night as well. We'll have an opportunity for that to be up there. As we said earlier, our speaker for tonight is Matthew Winton. He is an attorney here in town, and he has done these workshops for us for many years. You're in for a treat, and you're going to learn lots of information. So I hope you all have a notepad and a note. Your neighborhood. This is a great person for you to think about using their services. Okay. Our sponsor for the evening is Michael Bittinger Real Estate. Michael Bittinger, and his contact information is there, and we will also make sure that you have this information. Provides services for HOAs in the form of a management company. Okay. Michael, his management company was formed in 1988. He has both accounting and marketing degrees, and he has over 50 years of work experience in both. Okay. He currently has 8 associations, although I think that's a little bit outdated. I think he said he has a few more than that now. He has condominiums, townhomes, duplexes, and managements of all kinds. He's a management firm that does sort of a cafeteria plan, which is what I like about him. You don't have to fit into a category of, you take a lot of services that your HOA may not really need. If you just simply want someone to bill your dues every month, every year, or every month, that's all they'll do. Or if you want more services, you want them to be complete and be at every single board meeting as well, they'll do all of that as well. So if you need a management company, definitely talk to Michael Bittinger Real Estate Company. They're a great management company, and they are our sponsor for the Legal Issues series taught by Matthew Winton. Okay. Again, there's his contact information there. Thank you very much. And at this point, I'm going to turn it over to my dear friend, Matthew Winton. Thank you, Matthew.
Okay. Well, good evening, everyone, and welcome to, I don't know what installment it is of the Legal Issues Seminar, but we've been doing it for a very, very long time. I'm going to share my screen here and get our slides up for the evening. So the way we do this, if you're not familiar with the format, we talk for approximately 2 hours nonstop. This format on Zoom allows you to, get up, wander around the room, whereas before we didn't have that luxury, or we did, but it was disruptive. So just ask that you keep yourself muted, and because we have so many people, I don't know if we've had this many people registered. We had 100 or so registered for tonight. We're going to use the chat feature. I know for some of us that's a little cumbersome, but that's just that if you have a question, type it in the chat feature, and then Georgie's going to pop in periodically with those questions. It may be that we will cover that question, and the course is intended to cover it. So we may not answer your question right away. Just be patient. We should get to it. We try to cover a lot of ground with this seminar, and as with most things like this, here's the disclaimer. I'm not providing anybody legal advice. We'll do our best to hone you in on where to find information how to conceptualize, how to evaluate various legal issues that might come up with your homeowner association or condo association. But what I don't want you to do is to take something that you hear a tidbit of about tonight and run with it and believe that you can rely on that. No lawyer can tell you you're going to win a case. No lawyer can tell you you're going to get all of your money back. If they tell you that, they're lying to you. And then no lawyer can just throw out something without reference to specific governing documents, specific facts, and give you an opinion that you rely on. I know it's kind of cumbersome and infuriating sometimes. It seems like a lawyer won't give you a direct answer, but it's because if we're going to put our name and our bar number on an opinion, we want to make sure that we're looking at all the available information to give you the best information possible. Other resources that you could go to that I provide, there's a blog at okhoablogs.com. I've put some of these videos and past videos on a YouTube channel. You can search Winton Law HOA and you should be able to find it. We have some more information on our firm's website, thompsonwinton.com, and then also somewhat mirror the blog on Facebook and social media. So let's get into the materials. So we try to answer general questions and cover broad topics or concepts. For me, the starting place with any development, if a developer client comes to me, or if an association client comes to me, or an individual owner comes to me and says, hey, I've got a question about this. This could be, what covenants should I put in place for this particular development? What covenants are in place for this particular development? Does the association have to maintain the perimeter fence that goes around the development? Individual owner asking, am I a member of this association? All of those questions, I like to start at the very beginning. And the very beginning for most developments is a plat. I'm going to assume that most of the developments that we're dealing with tonight are community associations constructed around a recorded plat and a recorded set of covenants. If you're a condominium development in Oklahoma, they're called Unit Ownership Estate Act developments or unit ownership estates. We know them as condos. If you're in one of those, you probably don't have a plat. I actually looked at a condo development in the southern part of the state that it does have a plat. That's a little unusual, but every set of condo developments must have a declaration that's recorded. All right. And whether we call it a declaration of covenants, conditions, or restrictions, whether we call it an owner certificate, I know a lot of you call them bylaws, but we'll get into why you can't call them bylaws in just a second. But whatever the recorded document is with the county clerk's office that says what you can and can't do with your property, what structural restrictions are there, meaning how close to a side setback line can I build my house? What kind of roof pitch do I have to have on my house? Those are all structural restrictions. And then we have use restrictions. Things like, can I use my property to house chickens? We have a new slide for those of you who have been with us for years and years. We're going to talk about backyard chickens in a little bit. So that's a use restriction. What kind of business can I run out of my home? Can I have a home-based business? Could I have a saloon or a beauty shop? Could I have an Airbnb business? We're going to talk about that a little bit tonight too. Those are all use restrictions. And as a general rule, those are recorded with the county clerk's office along with the plat. Then we have another document. If the association's incorporated, in order to incorporate an entity in Oklahoma, you can't file articles of incorporation with a county clerk. Occasionally, I'll be doing a governing document research project. In other words, going through and making sure that I have all of the applicable governing documents, and I'll come across a filed set of articles of incorporation. Well, that didn't do anything. You cannot create a corporate entity by filing anything in the real property records. You have to record them. You have to file them with the Oklahoma Secretary of State's office. That's how you create what typically is a nonprofit, non-stock corporation for community associations. Then you have bylaws. Now, bylaws are not covenants. Bylaws don't tell us what we can and can't do with our property. That's a covenant. Bylaws tell us what we can and can't do with the corporation. Bylaws are a corporate document. They tell us what kind of notice we get as a corporate member. They tell us who the directors are or can be, officers, books and records, meeting, proxies, all of those business of the business kind of provisions. That's what we find in bylaws. And then we might have corporate resolutions, meeting minutes, rules and regulations to kind of round out the various governing documents that we would be looking for if we're setting up our governing documents file. And again, whatever the question is, it's more than likely going to be answered, or we're going to have to look in the governing documents for the answer. And we want to make sure that we're looking at the right documents, that we're looking at accurate documents. Sometimes I come across an amendment to covenants or amendment to bylaws that are recorded, and they clearly are not valid. Well, if we have an association that are working off an amendment that wasn't duly adopted, in other words, it's invalid, well, we have to make sure that we have the right document that we can go look at. All right, so let's look at a plat. This is a picture of a plat. This is a neighborhood off of Santa Fe in Edmond, and has a large common area water feature in the middle. And so this is something that plats will tell us. If our question is, what are the common areas to the association? Who maintains the common areas? Plats will answer those questions for us. Plats can also tell us whether there is an association or not. Oftentimes people think you'll look in covenants first to answer the question whether there's a mandatory association and who's a member. But actually the plat will often tell us whether there's a mandatory association and whether the lot owners in that addition, in that subdivision or plat, have to be members. So plat can provide us really good information. Let's talk a little bit about the development process. So generally speaking, and by the way, I don't just go through and read these slides. These slides will be made available to you. It's a little boring for me just to read down the slide, so I may paraphrase a little bit. And if I skip something that you see on here that you think is important, just use the chat feature and say, hey, you skipped, transition of community association. I want to know more about that, and we can talk about that, or maybe we'll get to it a little bit later. All right. So generally speaking, from the development process, a developer comes up with an idea. It's going to be public streets, private streets. It's going to have a water feature, not water feature. Sometimes they will have this idea of a theme. So you may be aware that there are equestrian themed developments. There are aviation themed developments. In other words, equestrian themed have perhaps common barns, they have riding trails, they are geared to market to people with horses. No surprise there that the covenants are going to allow for livestock, right? It wouldn't make any sense to ban animals in an equestrian themed development. In aviation themed developments, there might be a common area airstrip, hangars, things like that. So part of the zoning, the community association development process is putting into words what the developer's idea or dream is for the development. Now, it's not that that couldn't change. So there's developments. There's one in Edmond that originally it is called the Trails, but originally the idea was it was going to have riding trails, and just the way things go, it developed, and that never really materialized. So development idea can change, market conditions can change. Development could go from an idea of large standalone single family homes to zero lot line, little gated community within a community. So whatever that is, the developer is going to put that in place from the outset. All right. Covenants get filed, HOA gets incorporated, plat is filed, and only then, once the plat is filed and covenants recorded, should the lots be sold to end owners or consumers, right? This is a very important thing for developers to get right. So if we file a plat and we start selling lots and we haven't filed covenants yet, we have development lots that are now not subject to covenants. And that creates all kinds of needless problems. This happens sometimes. Developers will get a little antsy. They'll file a plat, they'll sell a couple of lots, and then they file the covenants. Well, those lots are not subject to covenants. There are instances where developer does a phase development, meaning they plat phase 1, file a set of covenants, plat phase 2, file a set of covenants, plat phase 3, start selling lots, sell them to a builder builds on those lots, no covenants ever filed. That's a big problem. That it is not an insurmountable problem. But now, instead of getting one developer's signature on a piece of paper that says these lots are part of a mandatory association, you have to go to each one of those lot owners. You can't just go in and file a set of covenants against their property. Needless problem created that we avoid by filing the plat and then immediately filing covenants right after it. At some point in the development process, the developer is going to be done selling lots. Some outfits are developer builder groups, meaning they not just set up the development, but they also build the houses and the structures on the lots. So whatever it is, at some point, the developer control period, developer is going to want to transition the community association to the resident owners. It's a normal process. It should be a seamless process. It should be something that we're getting ready for before it happens. Sometimes it's a little bumpy, but it doesn't necessarily have to be. During that period of time, there's going to be not only a transition of control of the association board, but there's going to be a handover of all the books and records that the association has, which may be a bunch if the developer's been operating the association for a while. It may be very few if it's a very small development and the association's only been up and running for a few months. Some developers don't charge dues during the developer control period. So if that's the case, there's no bank account, there's no vendor history. The developer's paid everything out of pocket. So there's really no books and records. So it really just depends on what the development history is. And there's going to be a transfer of the common areas to the extent there are platted common areas or areas that the association is to own. Those will be transferred, meaning deeded from the development entity or possibly a builder to the corporate community association. And then from that point, the association board, populated by the resident members, resident owners, they make the decisions. If you don't think the developer has done a great job of maintaining the entryway, well, once the transition of control of the association board happens, it's no longer the developer's decision. The resident owners now make all of those decisions. They control the association pocketbook. They control the level of goods and services that the association provides. So that's a little bit on the development process. Let's talk a little bit about the law, okay? So sometimes, and attorneys do this too, if we need a quick answer or a quick orientation on a document or a term, we'll Google it, okay? Nothing necessarily wrong with that. The problem with it is what you find on the internet may or may not be good information. I mean, I know I'm going to shock you with this, but there's information on the internet that's not true, okay? And it applies to homeowners associations just like it applies to political issues and all the other stuff that we see on the internet. So if you Google, Oklahoma Homeowner Association law, you might or might not land on something that's beneficial. So let's talk a little bit about what is the law, all right? So in Oklahoma, you can go to oscn.net and it will take you to the Oklahoma Supreme Court network. It's free. It is all of Oklahoma law, except for unpublished opinions, although you actually can get to them through oscn.net. You just have to really dig for it. But all of the statutes, all of the published cases, it's all free and has a pretty handy search engine on it you can use. And this is what the law is in Oklahoma. So, for example, if our question is our condo association, was it set up correctly? Well, we're going to go to 60 OS 501 et sec, which 60 is Title 60. OS stands for Oklahoma statutes, and 501 is the first section number. Et sec just means and following. So if you go to oscn.net, you type in the little search function 60 OS 501, it's going to take you to the Oklahoma Unit Ownership Estate Act, which is our condo act. And you can read and you can find the definition section. You can find the section that tells you that in order to create a condo, there has to be a declaration filed, that it has to be either attached to the deed to the first unit owner, or it has to be of record. Same thing with a set of bylaws. So it's going to give you all of those statutory or legal requirements for the valid creation of a condo. Okay, that is the law. In addition to that, any court who has made a decision, and that decision has gone up to our Court of Civil Appeals or our state Supreme Court, and that appellate court ruling gets published, that's the law. So any published opinion and statutes, that's the law, right? And so then I give you the citation for 60 OS 851. I say that's the HOA Act. The technical name is the Real Estate Development Act, or RETA for short. And then the Corporations Act, Corporations Code, also applies to those community associations that are incorporated, which should be absolutely all of them. I say should be, not that they all are. There are unincorporated associations out there, and we need to correct that as soon as we find that. And we'll talk about unincorporated associations in just a second. All right. So for those of you who have been joining, yes.
I have a question from two separate people now. The same question. What can you do if your developer has never conveyed your common areas to the HOA? So kind of guessing here, just from what I've seen, common area is typically not desirable land. If usually most developers, if they can turn it into a lot and sell it, they're going to do that. And so the reason we have common area usually isn't because we wanted this beautiful green belt area, or we needed to do that for marketing purposes. Usually either it's a swimming pool, a playground, some kind of legitimate recreational facility, or it's drainage area, and the municipality told the developer, we're not going to let you plat this unless you put this green belt in, okay? So either one, whether it's kind of undesirable land, drainage area, or it's actually a usable recreation, there's no reason for the developer to hold on to it. And in fact, the governing documents probably provide, the whole development plan
whether that's zoning, a PUD, which is a zoning category called a planned unit development, or the governing documents, they probably tell us the common area is to be owned and maintained and administered by the association, not held in perpetuity by the developer. Okay, so assuming all of that, usually when we come across common area that's still held by the developer, it's because the developer doesn't realize it, or they just haven't thought about it. They've moved on. It's just not on their to-do list or on their radar. And so almost in every case, we can go to that developer and say, hey, here's a quitclaim deed, sign it, and we will file it, and that will cure the title issue to the common area. Okay. Sometimes we have a developer who doesn't know any better, or who is being defensive, irrational, use whatever description you want, and they think that they can use holding on to the common area as a means to get something or prevent something. That's usually wrong thinking. You can't exactly use somebody else's property as a tool or a weapon against them. Ultimately, there's a cause of action in court that a lot owner or an association could bring to force the developer to hand over the common area. We want to be really diligent to try to avoid that, because that's going to be time, cost, energy, expensive. But ultimately, you could ask a court to make the developer hand that common area over. But again, it's usually not a stretch to convince them that it's common area, particularly if it's platted common area, then it's not supposed to stay with the developer.
So the next question, I think we know the answer, but if the common areas are already owned by the association when the turnover to the residents happen, is any additional paperwork needed?
Yeah, so on transition, sometimes, and this is a really good example of why Googling when does my developer have to hand over the association? That's a dangerous sentence to Google for Oklahoma community associations, because what you're going to find is a whole lot of information that tells you your developer has to hand it over after 75% of the lots are sold. Absolutely false for Oklahoma. That 75% comes from a uniform act, which a number of states have adopted, but not Oklahoma. And then you have other states like California that has the Davis-Sterling Act. And then you have Texas that has its own, and Florida has its own condo acts. Well, in Oklahoma, condo and homeowner association acts. Well, in Oklahoma, neither our condo nor the RETA tells us anything about when developers have to hand over. And frankly, when I do developer work, I draft the covenants that says the developer is going to control the association until they decide to hand it over, which is usually after they sell their last lot. So there's nothing specific in the law in Oklahoma that says this is what transition is, and this is what has to happen at transition. So we basically make it up. But we make it up in a way that makes sense and that mirrors what we would expect with any corporate transition. So think a for-profit corporation. If you have a wholesale exiting of the board, what do we want to happen? Well, we want the new board to come in without a fight. We want the new board to come in well-educated, well-situated to hit the ground running. And so if the association has a management company, which a lot of them do, because a lot of developers will hire a manager to handle the association before transition, then the books and records stay put, they stay with the manager. There might be a handover of profit and loss statements. There's definitely a handover of who controls the bank account, meaning there'll be new signature cards or depositor agreements executed. But apart from any deed transfer of the common area, the only thing that we typically have that examples that a transition has occurred are meeting minutes, because that is the corporate document that tells us the corporation did something, whether it's a board meeting or an annual member meeting or a special meeting, members meeting. Meeting minutes under the law are prima facie evidence of what happened at the meeting. What happened, that there was notice, that there was a quorum, that somebody made a motion and somebody seconded it, and we had enough people to adopt it, and that's what happened, right? And so at transition meetings, typically what we'll do is we will have a nomination of a slate of board of directors. We will ask the folks to vote to approve the slate. If they are, then you have a new board and transitions occurred. So typically we don't have, there's typically not a number of documents. There's not a formal transition agreement. There's nothing like that, because we're dealing simply with the transition of control of a corporate entity, right? Okay. Sorry, my computer stuck for a second. Okay, new slide.
Let me go ahead and ask one more question that's
Okay.
kind of along the same here, a little bit of what we're talking about.
Sure.
Let me find it again. I'm sorry. Are HOAs responsible for common areas that are not owned by the HOA, mowing and tree trimming?
So the answer is a firm could be, right? So for example, if you have an addition, like many additions, where you have an entrance, and then outside of the development, you have a little grassy area, people's fences or a perimeter fence, and then you have between the fence and the grassy area and the street, you've got a sidewalk, and maybe there's a little bit more of a grassy area. All right. So if you were to come to me and say, tell me who owns that little grassy area outside the fence, more than likely, and I say more than likely, but I don't know until I look at the plat, more than likely it is part of the platted lot and is owned by the lot owner, right? But in those instances, if there's a mandatory association, a high percentage of the time, the association is going to mow or maintain that little grassy area outside of the fence. And everybody lets them. Nobody questions whether the association should do it or not, right? Because if you ever drive by, so by my office off Memorial, there is a mandatory association and right next to a volunteer association. You drive by the mandatory association and you can pick it out immediately because the exterior is all uniformly maintained. It looks nice. You keep driving and you get to the voluntary association, and this isn't to knock voluntary associations, it's just this particular one apparently isn't really well organized. And the grassy area by the section line road is all uneven. I think one person has a vegetable garden growing out there. You know, it's up to the individual lot owners. And so there's a very good reason in some instances for associations to maintain property that it doesn't own. And that's probably the number one. Well, if you think about that, at the development stage, we don't have to leave some of this stuff up to people scratching their heads. You don't have to keep paying a lawyer, their hourly rate every decade to answer the same question over and over again. We can just plug that right into the covenants. The way we commonly do this is we'll have a definition of common area, of course. Common area in my covenants, the ones that I typically draft, we'll define common area as areas that the association owns, areas that the association by contract or by agreement is responsible for maintaining, areas that the association leases. So we create this umbrella of maintenance property or obligations that the association has voluntarily taken on, so that we don't have this question, okay, whose responsibility is it, and why are my dues going to mow this property that's owned by someone else? Well, it's because we've set up the system from the outset. The association's always been doing it. It's not something that we just decided, hey, let's start throwing money at this thing. All right. So another way to do it is you have definition of common area, which is property that's owned by the association. You have a separate definition called area of common responsibility. And this is a drafting technique that some attorneys have used over the years to kind of differentiate between hard and fast platted common area that the association owns or is entitled to, and then these other kind of squishy areas that, well, we don't want the association to own it, or the association doesn't own it, but we really want the association to maintain it. So we're going to call it area of common responsibility. So however we do that, it is common and entirely appropriate in some instances for the association to maintain property that it doesn't own. All right. Georgia, you want to clear any more, or we want to?
One that I'm not sure that you cover later, but you might. How can you find out if your HOA is registered / legal?
Okay, that's a very broad question. We could run down a couple of different rabbit trails on that. So registered, there is no registry system in Oklahoma, no central registry for community associations. What you're going to find are various municipalities that have registries. The Tulsa Mayor's Office used to do that. I haven't checked in the last couple of years to see if they still do that. Of course, if you're a member of Neighborhood Alliance, they will have their membership list and can work with you to make sure that you hit a number of those legal things.
And let me just interrupt real quick. We're not a membership organization. It's free of charge, but we do ask all HOAs and neighborhoods in Oklahoma City and Oklahoma County to register at Neighborhood Alliance. The city of Oklahoma City does not know you even exist, believe it or not, unless you register with us. So if that Walmart is going to build in your front yard, the people within 300 feet are going to get a notification, but your HOA president is not, unless you're registered with us. So if you register at Neighborhood Alliance, we will make sure that you get notified of all zoning applications, any kind of thing that happens around your neighborhood. Your city council person will know how to get hold of you in case of anything that needs to happen. You'll know what's going on around you. Otherwise, you won't know. So we encourage you to register. That registration, that information is held confidential. We do not share it with anyone but the city and the police department. But we do ask you to please register and update your registration. You can do that on our website. And anytime you have new officers, please go in and update it. But it's not a legal thing. It's only to keep you and your neighborhood updated as to what's going on around you and with your neighborhood.
Yeah, so in terms of trying to answer, how do we know if we're legal? I'm going to rephrase the question just a little bit and kind of go back to what do we look for in a community association that is well set up, right? So having a set of covenants that are recorded prior to lots being sold. Of course, as a matter of law, if someone's going to sell a condominium unit, there has to be a declaration and bylaws filed. It's a very rare occurrence. I've only come across it a couple of times in 20 years where we have some kind of material defect in condominium documents. I had a project once where after, goodness, this development had been in existence for 30 something years, determined that the legal description, it wasn't complete. It didn't actually describe condo units. So we had to go back in and do an amendment, and that's fixable, but making sure that we have proper legal descriptions, that we have language in the covenants that does what we want it to do, making sure that if we have a mandatory association and are filing liens and foreclosing on those liens, that the association actually has the right to do that. I will go into considerable depth on liens and talk about who can sign them, who can file them in subsequent slides. But beyond the real estate side, we want to make sure that the association's incorporated. And you can go to the Oklahoma Secretary of State's website. Of course, it's kind of a chicken and the egg thing. What do I search for if I don't know if my association's incorporated? Usually you'll just search for the name of your development. So if you live in Blackacre Estates subdivision, go to the Secretary of State's website, search Blackacre Estates, see if if the search produces any results. Blackacre Estates Homeowners Association, Blackacre Estates Property Owners Association, and try to determine if your association is incorporated. If it's not, incorporated immediately. Okay, that is if you take anything from these 4 hours over the next couple of nights, remember, make sure your association's incorporated if it's not incorporated. And then the part 2 to that, if your association was incorporated 20 or so years ago, read the articles of incorporation, because you want to make sure the term of existence in your association's corporate articles of incorporation provide for perpetual, meaning forever. Okay. The reason is, once upon a time, the law required a maximum of 50-year term for corporations. You'd have to go in and renew them. And then I believe it was in the 80s when that changed and allowed for perpetual terms of existence. So a lot of those older corporations, whether they're for-profit or non-profit, like our HOAs and condo associations, they may have 50-year term of existence. So make sure you don't wake up one morning and find out we were incorporated, but it expired on its own terms, and now we're dealing with an unincorporated association. All right. But talk a little bit. Oh, go ahead.
I'm going to ask one more question, and then we're going to go on with your slides. If
Okay.
the developer will not turn over the HOA and will not spend the dues money on things that we, the homeowners, feel are important, what is our recourse?
All right. So the purpose of an association board, whether that board is populated by developer people or resident owner people, the purpose is to spend the association's money. And the people in the driver's seat get to determine where the car is going, or the captain and his crew or her crew to determine where the ship is going. So I like car and ship analogies for some reason for these boards, and I use them probably too much. But so if you don't like where the car or the ship is going, then you need to be in control of that car or ship. And it works the same way with corporations, right? To the extent we can, we want to keep this out of court, but ultimately Oklahoma statutes provide a means that contested director elections can get in front of a judge, and the judge will make a decision, or the judge will oversee the election. I can tell you the last thing a district court judge wants to do is babysit a bunch of adults in an HOA or condo corporate election. They're not going to like anybody in their courtroom when that comes in front of them. So we try our very hardest to demonstrate, look, this was the last resort. We tried to do everything we possibly could, make agreements, hold, I mean, we all know what a free and fair election looks like. Okay. I mean, and it's not like we're taking over a country here. We're talking about a community association. So if the developer simply will not hold an election, and they have to, okay? And I say that because I do a lot of developer work, and I hear a lot of the complaints from resident owners that developer is holding on to the association and needs to hand it over. Well, maybe from a political standpoint, maybe from a customer service satisfaction standpoint, but maybe not because the governing documents require it. Again, if I have drafted those documents, the developer can hold on to the association until they sell their very last lot. They don't have to hand it over, and they can spend the money however they choose that suits their discretion. Now, when the new board comes in, they can spend the money however. But if it is a circumstance where the developer is no longer contractually by covenants or by bylaws able to hold on to the association, well, then it's simply a matter of a corporate vote. I have been involved in situations where boards, whether they're developer or otherwise, simply will not call for an election. They, for whatever reason, they will not allow a free and fair election. And if that happens, there is a mechanism under Oklahoma law, if not the bylaws, where the members can cause a special election and they can throw the entire board out. And if you have a board who is unwilling to hold a special election, hold a vote of confidence, they need to be thrown out, right? And so there's always a means to take over control of the association. You just have to convince enough of your neighbors, your other association members, to agree with you that the developer or the other whoever's on the board is doing such a bad job to at least execute a proxy and give it to you, or to show up and to hold a special meeting. So there's always a means. What I find is folks want a rifle shot, or they want some kind of lawyer letter that will make people do what they want them to do, and that does not exist. There are processes and procedures where you can hold elections, you can cause special meetings to occur, and then if you have someone who simply will not honor the rule of law, well, then you have to go to court. But you only go to court after being able to demonstrate to the judge, look, we did absolutely everything we possibly could. And we have someone here who's not playing by the same rules. I mean, that kind of board is someone that has been beaten at checkers, and they're moving pieces against the rules and stuff. You at some point you have to end up in court and have a judge take care of that. So it's not an easy process, but it is certainly doable. All right, let's talk about a couple of ordinances. So we're going to talk about Oklahoma City ordinances. I know that there are other towns that have both short-term rental ordinances, definitely backyard chicken ordinances. We're going to use Oklahoma City as an example. Most of these ordinances are going to be somewhat similar, substantially similar. And so in Oklahoma City, on the home share, short-term residential rentals, you can do that in Oklahoma City. It requires an application. That application requires statements made under oath, which means you're promising on paper to tell the truth and not lie. And you go through the application process. Ultimately, you receive from Oklahoma City a business license. Well, that's great, except if there are covenants that prohibit businesses in your neighborhood. Okay. What you've done with this application process, if you live in a neighborhood with a no commercial activity, which is one of the most common, if not the most common covenant for residential neighborhoods. It's one of the big ones, right? That's what we put in covenants so that this stays a residential neighborhood, is no businesses, no commercial activities, no noxious or offensive activity, okay? Well, if you've gone through the process, or if you have a lot owner who's gone through the process of getting a business license from the municipality where the property sits, they have just said we're violating the covenants, and they've done it under oath, right? So we have to be really careful in Oklahoma City that we don't get excited to get our Airbnb going. If you're in Oklahoma City and you have covenants that prohibit business, the covenants can still be enforced. And this is something that I think sometimes folks miss, whether it's public street parking, whether it's short-term rental of property, whether it's backyard chickens, whatever it is, unless the government has preempted private contracts in that area, the fact that the government tells you you can do something doesn't mean your association can't tell you you can't do it. All right, let me give you an example. So in Oklahoma and at the federal level, we have a Flag Act, all right? And the federal and the state Flag Act, they say you can fly the American flag, you can fly the state flag, provided you fly it according to whatever the laws say to display those flags. And to the extent that any covenant, restriction, rule prohibits it, they're null and void, all right? So what the government has done has said, okay, we find flying flags appropriately so important, we're going to preempt private restrictions of those, all right? Well, the home share ordinance, the backyard chicken ordinance, you don't find that kind of language in these ordinances. So if an association, or excuse me, if a development has a covenant that says no street parking, the fact that all the streets are public is immaterial as to whether that covenant can be enforced. The fact that the city of Oklahoma City says you can home share your home and you have a business license to do it, it's immaterial if you have a covenant that says no short-term rentals for your property, okay? Same thing applies for backyard chicken ordinances. And by the way, I'm a big fan of chickens. We have had chickens from mail order baby chicks to buying layers. I love chickens, they're fantastic. But if the developer or if a sufficient percentage of your neighborhood has said no livestock, no swine, no backyard chickens, no more than a reasonable number of dogs or cats, well then, if unless the covenant is ambiguous or otherwise waived, then that could be enforceable. But in Oklahoma City now, and this is brand new, Edmonds had theirs for a couple of years, I think since 2019. Norman might have a backyard chicken ordinance, and they might have had one for quite some time. I don't know off the top of my head. But anyway, in Oklahoma City, you can have 6 hens or quail, no roosters. For those of you that don't know anything about chickens, you do not have to have a rooster in order to have eggs, right? Hens just lay eggs, rooster not required, okay? And roosters are, they're loud and they're aggressive. So that's why these ordinances will allow hens. I think Edmond only allows 4 hens per third of an acre. So 6 hens or quail is pretty generous. All right. Of course, there are housing requirements. There's some kind of restraint, dusk to dawn, although again, most chickens, if you provide them housing, they're going to be in there as soon as the sun goes down, and they won't come out until the sun comes back up. Really fascinating creatures. And then also with this one, the covenants of your neighborhood could still restrict. So for example, if this is a common occurrence where I find boards feeling compelled to enforce covenant language because it's there. They feel like, well, if we don't enforce this covenant, well, then maybe we're being lax on these other covenants when it comes time to enforce it. And they find themselves taking positions that they themselves may not be in favor of, and maybe the majority of the neighborhood isn't in favor of. For example, backyard chickens. So this ordinance goes to effect in Oklahoma City March 4th of this year. Your your development may have a restriction that says, no poultry. It may be time to take a look at and have a conversation neighborhood wide of whether you want to amend that to allow for backyard chickens and quails in compliance with whatever the ordinance is where your neighborhood sits. Not that you have to, but it's built into the covenants. It's also built into Oklahoma law, and we'll talk about this later on amending your governing documents, whether it's filed covenants, whether it's articles of incorporation, or whether it's bylaws. All right. I'm not going to spend much time on this other than to reiterate, find out whether your association is incorporated. If it's unincorporated, figure out, hire someone, do whatever you need to do to get it incorporated. It's not complicated. It's a filing with the Secretary of State. There's better articles than others, but if you just get it done, just get it done. All right.
Matthew, we have a question that comes up a lot of phone calls in my office also. Our covenants state no parking on sidewalk, so your car must be all the way in the driveway. Also, city ordinance states this. Police have been told to not enforce. So what can we do?
This is a tough one because, and it may be one of those, the board wants to evaluate, well, yes, the language is there, but is this something that we want to take time and resources in order to enforce? It's not impossible to find a towing company that will tow someone out of their own driveway. It's going to be a difficult sell though, and almost certainly is going to require an indemnification agreement executed, if not by the individual board members of the association, but by the association to the towing company. All right. So towing company says, sure, we'll tow it as long as you indemnify us when the owner sues us for yanking their property off their property. So if the board really wants to clear the sidewalks and can't convince the municipality to do it for them, then they could make a run at enforcing the covenants and having a towing company try that. They could look at doing a fining or a monetary penalty system. They could look at going to court and obtaining an injunction. And I'll reiterate it again now. Each of those things that I just mentioned, you cannot take away from here and say, hey, the lawyer said we can start towing cars in our neighborhood. I didn't tell anyone on this video that you can tow cars. You would have to have the framework in your covenants. You would absolutely want to put in place what's called a due process hearing, or an opportunity for the property owner to contest the towing before it happens. There has to be groundwork, not only in the real property covenants, but also in the process by which the association would go about enforcing a you can't park in your driveway in front of the sidewalk restriction. Beyond that, it may be one of those that the language is there and needs to be gone. Functionally, it may be, and I've seen this where there's a covenant that requires trash cans to be housed out of sight or on the side of the house. And the way the houses are built, it's not physically possible to move the trash cans to the side of the house, which only leaves the trash cans in the garage. And board members taking the position, well, that's where you have to put your trash. No one is going to house their trash in their garage, right? It's not practical, and you're just going to fight about it. So that's one of those things that we need to think, yeah, the language is there. Yes, it's difficult to amend covenants, but have the conversation among the board. Is this something that we want to spend time and resources on, or do we need to figure out a more elegant resolution? Sidewalk parking is also one of those.
Matthew, since you mentioned fines, let me ask this question. If our protective covenants and our bylaws do not specify amount of violation fines, does the board have the leeway to set and establish fines for different violations?
So in order to charge a monetary penalty, the covenants have to specifically identify and give notice that a person could have money taken away from them by the association for not following the covenants. Now, it doesn't exactly have to say that, but the language that people usually come to me and say, hey, this is what we're using to fine, is some general language that says the association or a lot owner who's aggrieved by the violation of covenants has an action at law or an equity or for sums due. You know, there's usually a general enforcement block of language in every set of covenants. That's not good enough. It's certainly not good enough to have unfiled bylaws that say, or even covenants that say, the association board can adopt reasonable rules and regulations. That doesn't tell me you're going to adopt a rule and take money from me if I violate the covenants. I mean, I hear all kinds of ways to get around what every court that I've seen outside of Oklahoma, because we don't have a court case and we don't have a statute in Oklahoma on this, but courts who in other states that have reviewed this almost uniformly, absent some kind of statutory exception, the covenants have to give adequate notice that the board has the ability to adopt monetary penalties, and there has to be some kind of due process sequence so that people aren't surprised by the monetary penalty. And if we want it, just put the language in the covenants. I put that language in every single one of my covenants that I do for developers. That is probably the #1 covenant amendment project that I do across the state, followed quickly by some kind of leasing restriction or some administration of leasing. So the fine schedule is typically not itself put in the covenants. We usually leave that to either the board's discretion and adoption, or we leave it to the process of the members adopting whatever the fine schedule is. But we have to have that authorizing, that organic language in the covenants, in the recorded covenants. Something that I find, which is mind-boggling, is, and even attorneys advising clients that the corporate entity has the authority through the board to adopt rules, and therefore they can adopt monetary penalties, and therefore they can enforce those penalties by filing a lien against people's property, and then they can foreclose that lien. That is mind-boggling to me, because the Real Estate Development Act and the Condo Act are very specific on how, when, who, when it comes to filing liens. And it doesn't say we can just make this stuff up, just like we can't make up late fees or penalty interest. You know, I find sometimes management companies or community associations tacking on this $25 late fee. And we ask the question, okay, we see this $25 late fee on your account statement. Where does this come from? Oh, we just put it on there when people don't pay their bill. Well, good grief. Why stop at 25? Why not make it $100? Why not charge them $1,000? Well, that's unreasonable. Well, yeah, because you're not authorized. You're not allowed to do it. Anything that we want to charge people, particularly if we think we're going to file a lien against their property, we better be relying on recorded covenants. Okay. Now, there are very, very limited circumstances where there are associations who are built around a corporate entity kind of structure, right? That would be the one exception that I could find where maybe we could do rules, or excuse me, corporate-based liens and fines. But that's a very narrow circumstance. I can think of 3 in my practice right now, and they're all over the state, and they're usually very old associations that were set up as corporate entities primarily, and courts have upheld those kinds of regimes. But your run-of-the-mill plat, covenants, community association, we have to have specific language in our covenants authorizing monetary penalties. All right. Any other questions, Georgie, to field, or we could talk a little bit about it?
How are we doing? Are we asking too many questions for you to get through your slides?
No, I can cover these others.
Then I do have one more question about, can covenants keep cars from parking on city, public, non-private streets?
Yes.
You kind of danced around it a little bit while ago, but you didn't answer that specifically.
Yes, without a doubt. Just like if the ordinance says you can have backyard chickens, if an ordinance says you can park on public streets, you can have covenants that prohibit those things. So yes, you could have a covenant that prohibits parking on public streets. Yep.
But like you talked about earlier, it's sometimes hard to enforce and find somebody to tow. You talked about that.
It is easier. It is easiest. I'll give you a spectrum. It's easiest to find a towing company that will tow vehicles on common area, right? That's just like, this car's parked in my driveway. I've asked them to leave. They told me to pound sand. I want you to yank their car off my property. No problem, sir. It's your property. You get to decide what to do with it. It's the same way with common area. Okay. The very next category would be towing company. We have a covenant that prohibits parking on the street. We've given them notice. It doesn't matter if it's a public street or not. And we're asking you to tow it. Towing companies will do that. Okay. The hardest category is towing a vehicle off someone else's property. That can be problematic, right? But yes, I'm aware of neighborhoods that have towing companies come in and will tow vehicles off public streets.
I have a question about quorum. Are you going to be talking about that a little bit later?
I am. Yep.
Okay. I'll hold on to it then.
Yeah, I've got a couple. That one's a couple slides away. We'll cover.
Okay,
quorum.
that's what I thought.
All right. So I'm going to talk. Excuse me. I'm going to talk really quickly about just some meeting practice things. So I've been in some meetings where things just went off the rails. I mean, people throwing chairs at each other, fist fights. And then I've been in HOA meetings where it was like a day at a spa. I mean, you come out there feeling better about yourself. You feel better about humanity. It was wonderful. Well, you usually can gauge is this, which end of the spectrum is this meeting going to be? And it is possible. I mean, forget what you hear on television and what you read on social media. It is possible for us to talk to one another civilly, even if we vehemently disagree, fundamentally disagree. I mean, you think the pond water ought to be natural, and I think we ought to dye it green, not just on St. Patrick's Day, okay? We can fundamentally disagree on pond water quality, and we don't have to go to war over it, okay? If we think that people are going to be disagreeable, if we're going to have a contentious meeting, it's the board's job to try to diffuse that, to try to get out in front of it, to remind people to be on their better behavior, to use their inside voice, to remember there's certain language that used to be inappropriate to use in front of children that I'm hearing in meetings, and it's blowing my mind. And so boards can remind its members, look, folks, before we get into the discussion, what we're going to do in this meeting is remind each other that we're going to treat each other like neighbors. At the end of this meeting, we're going to remain neighbors. I'm going to do my very best, and I'm going to ask you to hold me accountable to speak to you the way I want you to speak to me. We do have young children in the room, so we're going to not use profanity. We're going to try to keep our voices at a conversational level. And we're going to remind each other from time to time if somebody gets emotional, because we're going to talk about emotional stuff, to dial it back and to remember what we've committed to one another for this meeting, okay? Some kind of statement of civility goes a long way. And what it does is it sets the benchmark for how we're going to talk to each other and what we're going to allow at the meeting. So what it does is if I'm chairing the meeting, I've set the benchmark, and I've set it not just for everyone else in the room, I've set it for myself. I mean, I've been to an annual meeting one time. It was in a high school cafeteria, and the meeting was going south pretty quickly. And it was done when the president, who was chairing the meeting, was yelling profanities from the board table. I mean, who's going to listen to that guy after that? No one. The meeting was over. So if we can set the benchmark and remind people as they get emotional, which people normally do, that's understandable. There's nothing wrong with that. It's even appropriate sometimes board members to acknowledge that, okay, take just a second. It seems like you're worked up and emotional, but we want to hear you. I mean, a little support and reaffirmation goes such a long way in reminding, particularly for board members, reminding the members, hey, look, we're servant leaders up here. We're not getting paid. We're volunteers. We're giving up work, family, leisure time to try to lead you the best we can. We really do have your best interests at heart, and part of that interest is hearing what you have to say, even if it's somewhat critical. So however you do that, however you as a board decide to do that, it works. It's one of those pro meeting tips that I know immediately when I go to a board meeting that this board has it going on in terms of how to speak to one another, how to speak to the members. I could probably guess what their social media looks like and how they speak to one another, how they speak to their members on that, how they allow the members to speak on social media. It goes a long way. All right, very quickly, the Open Meeting Act, the Open Records Act do not apply to your association, okay? I say that not having read your articles of incorporation or bylaws, because only a lunatic would require the Open Meeting Act and Open Records Act to apply to a community association. They don't apply. By their definitions, they don't apply. If a person tries to amend your bylaws or articles to include the Open Meeting or Open Records Act, you want to say no. And if you're on the board and somehow they are successful, you want to resign immediately. The Open Meeting, Open Records Act carry civil, criminal, monetary penalties for violations. They require filing of notice of meetings with Secretary of State and with county clerks. They are not designed to apply to your association. There's no reason in the world to make them apply. Okay. All right. I'm going to talk very quickly about meeting minutes. I said earlier that meeting minutes for corporations are prima facie evidence of what happened. What that means, I'll explain what that term means, because it's very important to a guy who sometimes has to stand in front of a judge or a jury and explain, okay, this is what the association did. This is the record that proves what they did. Meeting minutes, when I say they're prima facie evidence, it means on the face of the document, we can assume that what it says is actually what happened. Now, that's what's called a rebuttable presumption. In other words, if I have a piece of paper that says there was a quorum and there was a motion to do this, and they seconded and they approved it, 5 years later, I'm holding that piece of paper, I can rely on that until someone comes up and says, hey, I've got a video of the whole meeting. There absolutely was not a quorum and they couldn't have taken this. Okay, well, maybe somebody dummied the minutes. That's possible. We have to allow for that. And if somebody has good evidence, reliable evidence that that's what happened, well, then we'll go with that. But until somebody rebuts the presumption, we can rely on meeting minutes. That's why they're important. That's why your association needs to keep them and maintain them. Now, minutes are only a record of what happened. They are not a transcript. So we want to know that there was adequate notice of the meeting, that there was a quorum. If it's a board meeting, we typically will identify who was there. If it's an annual meeting or a members meeting, we want to have a sign-in list or some establishment that, yes, there was a quorum and this is how we determined it. Maybe have proxies attached to it, or definitely identify how many proxies were there and who held them. And then it's just a record of motions, seconds. If there were reports attached to the report, it's not a transcript. It doesn't say, you know, Matt said this and Georgie said that. And Matt said, George, that's a great idea. Let's do that. And then we did it. It doesn't contain that kind of detail. It can, it just doesn't really need it. That's not its purpose. All right. Georgie, you said there was a question about quorum, and a quorum is simply the minimum number of people that we need either in person or by proxy in order to conduct business. Okay. If the one of the common questions is, well, where would we find our quorum requirement? And the first place we'll look is the Articles of Incorporation. Often not there. Almost always they're in the bylaws, but I read a handful of bylaws that don't have a quorum. And then if our bylaws don't have a quorum provision and our association is incorporated, well, then Oklahoma law provides that quorum is 1/3 of the total voting membership. All right. And then that bottom bullet there, earlier I talked about there was a means for a court administered election if we can't get a special meeting, or if the board somehow, you know, creates a controversy and we need to go to court, have a judge oversee an election. The quorum for that is whoever shows up. So that process is designed for a result, and that result is we're going to have a board elected regardless of who shows up. So Georgie, does that cover the quorum question that they had?
No, it helps, but she was mainly talking about, she said that the quorum is the bane of all HOAs, which I think we can all agree.
Agreed.
And said, is there a recourse? And I was thinking about your diminishing quorum language that you've so wonderfully shared with so many before.
Yeah, so quorum is notoriously difficult to get, whether we're trying to get corporate business done, whether we're trying to amend covenants. It's usually not the no votes or the disagreement with whatever the issue is. It's apathy. Apathy is just the killer. I mean, you look at some of our most important elections. Think about school bond issues, political elections. I mean, the turnout's notoriously low. Well, it's the same for community associations, whether it's the annual meeting and we're going to elect directors or adopt a budget, it's low. The way to do that is proxies, okay? I prefer, I mean, if we have an unworkable quorum, if it's a 50% quorum, well, that's unreasonable. There's no reason to have 50% of the membership present in person or by proxy for quorum. 1/3 is workable, 33 1/3%. Sometimes you'll see 25, even down to a 1/10. And the argument for those low quorums is, well, look, if you're concerned about something hinky going on, well, then show up. Convince enough of your neighbors to show up, and goodness, you'll probably control the vote. So I don't necessarily have a problem with low quorum. What I want to see is a mindful proxy practice. So in Oklahoma, and I hear this sometimes, that we had a board takeover. There was a board that was unreasonably obstinate in holding elections and had a lawyer that was helping them, taking mind-numbing positions, things like they don't accept proxies unless they're notarized. Well, if you have a board or a lawyer telling you that a proxy has to be notarized, they're either woefully misinformed as to the law, or they're trying to hold on to power. No proxy has to be notarized. You could send me an email. You could send a message in the chat function of this Zoom, and that serves as a proxy. A proxy could be written on a cocktail napkin in crayon. I mean, it doesn't matter. It certainly doesn't have to be notarized. What the association should do is have a very well drafted, easily understandable, easily submitted proxy form, and they need to use that routinely and send it to their members. We need to be using email. The idea of you've got to have a piece of paper proxy and a person has to physically come to the meeting. We should have buried that a couple of years ago. And I think there's enough people using Zoom now, enough people hopefully online familiar with email, that we can use electronic proxies. It's expressly allowed under Oklahoma law. Electronic notices, electronic ballots and voting, electronic meeting. You could run 100% of your association business, whether it's board or general membership, online and electronically. Now, whether you should do that or not is up to you. It kind of depends on the demographic of your neighborhood. A lot of associations now are doing a hybrid. In fact, I do a number of transition meetings for developer clients, and we're doing hybrids where I'll be in person and we allow for a Zoom component. And we do board elections, we do board nominations, we run a regular HOA meeting. So there's no reason why your association couldn't do that as well. All right,
Okay, I have a few more questions on quorum. I'll ask them all in one question. Does quorum diminish with the age of the development? Do you have to have, how can you change your bylaws to have diminished quorum? And do your bylaws have to state that you can use proxies in order to use proxies?
Okay, bunch of good questions. The answer to the first question is no, quorum doesn't diminish over the age of the development. It could be drafted that way. I've never seen that. That would be interesting, but no, typically quorum is a hard and fast percentage. Now, there are diminishing quorum clauses where the bylaws will provide, you give notice if on the date of the meeting, there's not a quorum, well, then you can adjourn that meeting, give notice, and at the next meeting, and this is where the language varies. Sometimes it'll say you'll have half a quorum, or whoever shows up at that next meeting, there will be a quorum. One of my favorite things to do is, if the language allows us, advise the association, send out one notice. And the notice, and this, again, this is where you have to be careful. You can't take what I'm about to say and say, great, we've got diminished quorum, well, let's do it. It only works if you have the language in your bylaws. But what the language that I'm talking about allows you to do is send out one notice. That notice says, hey, folks, at 7 p.m. on such and such date, at such and such place, we're going to have our annual meeting. At 7:05, if we don't have a quorum, here's your notice that we're adjourning the meeting and reconvening, and we will have whatever the quorum clause allows us to do. We will have a diminished quorum, or we will have an established quorum. It doesn't work if the diminishing quorum requires a space of time between the two notices. That's the key. It has to allow us to combine the notices for those two meetings in the same mailing or in the same email. It often does. It doesn't always, though. So we have to be really careful that if we're going to do that combined notice, in order to get that diminished quorum at that meeting, we have to make sure that the diminished quorum clause allows us to do that. All right. And then I forgot the third one. What was the?
Do you have to have proxies in your bylaws in order to use proxies?
That's right. The answer is no. No, your bylaws can be completely silent on proxies. Proxies are a function of statute, and consider it like a limited power of attorney. I could give that because we're dealing with a corporate right, not a real estate right. The proxies akin to a limited power of attorney for a personal property right doesn't have to be recorded, doesn't have to be notarized, doesn't have to be authorized by the bylaws. All right, I have a slide on proxies, a little more information. Typically, proxies expire on their own after 3 years. That's what the statute says. You could make it longer. Typically, a well-drafted proxy for a community association is going to be live until killed, meaning I'm giving my proxy to whoever it is, the chair of the meeting, to do whatever they want to with for as long as I'm a member, a lot owner, or until I give notice otherwise. That way you don't have to keep getting proxies over and over again each year after year. Okay, we talked about electronic voting. I did some FAQs. We're 30 minutes out. I'm gonna spend a while on enforcement. We don't go into all the detail. We'll talk about injunctions and collections. Next week, we go a little bit deeper into, well, we cover collections, foreclosures, liens, injunctions, insurance, and amending covenants. So we don't really get into that tonight, but I am introducing covenant enforcement. We already talked a little bit about monetary penalties. No secret, monetary penalties are one of the most effective remedies an association can have. That's why I think that's the number one amendment that I'll do across the state for associations is if they have a set of covenants that don't have monetary penalties in them, they realize how effective it is. And I'm saying effective, not because it's effective in punishing people. enforcing covenants is never about punishment. Okay. I think that sometimes gets lost. It's not about making people do the right thing. Because oftentimes the level of enforcement, it depends on how much money the association's willing to spend, right? There's no one out there that's going to carry the enforcement water for the association. The association has to pay its lawyer to enforce it. Now, these may be prevailing party attorney's fees cases. If the association prevails, they may get their money back, but no lawyer can guarantee you're going to win the case and get all of your money back. This is after this speech, when I talk to clients, that's usually when I hear, well, then what teeth do covenants have? What good are covenants if what you're telling me is true? Well, what I'm telling you is they do have teeth. They have big, nasty fangs that you can sink into a defendant. You just have to pay for it. And you may get your money back, you may not. All right. So given that we all know that there's risks in litigation, that it's expensive to go into litigation, one of the first things that we want to do is this. And I have a picture illustrating. The first thing that we do is ask the question, are we seeing this from all possible sides? Okay. So this is a picture of one of the royals. From one side, it looks like he's giving the American, middle finger, and another angle, he's giving it the British three or the European three, however you want to look at it. Right. I like this picture because it reinforces sometimes we're not seeing the entire picture. Sometimes we need to ask the question, is there more to this than what meets the eye? Do we need to go through a process of asking some questions before we hire a lawyer and fire off a demand letter? The answer is always yes. If you come to me to enforce the covenants, to send a demand letter, I'm going to ask all of these questions. I would hope there's other lawyers out there that are going to require their clients to ask the same questions. Did you go to the person and talk to them? Did you determine whether there's some kind of misunderstanding? Did you figure out, are they not thumbing their nose at you, but are they going through something that is preventing them from complying with whatever the covenants is? I'll give you some examples, because a lot of times what I hear back at this point is, well, they got a copy of the covenants at closing. They should have read them. They are in the same boat as everyone else. I can mow my yard. Why can't they mow theirs? All of that stuff. I get it. Yeah, sure. Yep. You can enforce the covenants. And you could also go the extra mile and ask the questions that I think should be asked, because I know there are situations that I've been in that I would have liked the other party to have asked those questions before sending a demand letter or taking the position that they did. So for example, I've sent a demand letter to a lady, this was a couple of years ago, right at the start of COVID, that had an old car, I think it was a Corvair, parked in her driveway. And it was clearly not operable. I can't remember if it was on Jack's or what. It's in a nice neighborhood. So we send her a letter. The association sends her a letter. No response, just completely thumbing her nose at them, right? Didn't even take the time to respond. So then I send a letter and doesn't respond. Finally does and says, sorry, I was getting to it. I've had, I can't remember specifically what she said, but the crux of it was her husband had died of COVID, and she was busy getting her affairs in order and reorienting her life to being a widow. And the last thing that she was concerned about was the Corvair in her driveway. So that is an instance where absolutely the association could have filed a petition. could have enforced the covenants and been well within the association's right to enforce them, but that's not the case that you take to court. Okay. Other instances, we'll talk about collections next week. If we have a lot owner, typically an immigrant, who English is not their first language, and they have no idea that there's such thing as a community association, they get a bill, they don't pay it. Oftentimes what those cases need is education and communication as opposed to a lawsuit or litigation, right? So looking at, all right, is there a conversation that needs to be had? Beyond that, is there a formal function built into the covenants that requires us to provide some kind of notice, some kind of hearing? And what you're looking for here is something that may say due process. There's something, there's a phrase called a hearing en banc, and that just means in front of the entire board. Is there an appeals process? So if what we're talking about is an architectural review committee that has told someone, no, you can't have those solar panels, or no, you can't build that greenhouse, is there an appeals process from the ARC to the board? Well, if there is, we have to honor that before enforcing the covenants. Beyond that, sometimes we'll find formal mediation, meaning required mediation, which is a little unusual because mediation is non-binding. So there are covenants that require you to go to mediation. Of course, it can't require you to settle, but the idea is just to get the matter, get the conflict and parties in front of a third party, and possibly there's a settlement without going to court. Finally, there's binding arbitration. Binding arbitration is essentially a private court system. Instead of going to court, you go in front of an arbitrator. That arbitrator can issue injunctions, can oversee discovery, excuse me, and treat the case just like a court case would. So knowing what those non-judicial remedies are, it's important, not only just to know how to possibly avoid court, but also it's a requirement if it's built into the covenants. Okay, so enough on enforcement. Like I said, we'll talk more about that next week. I want to spend some time on books and records, and then see what questions folks have, and spend the rest of our time being available for questions. This is one of the biggest issues that I find in my practice that comes up. It comes up with the transition, like we've talked about, from developer to resident owners. What are all of the books and records of the association? Are they being handed over? We have this recently in our office where a manager, their services were terminated, and we're dealing with the transition of those records from that former manager to the new manager. Oftentimes, though, I would say the highest percentage is individual member of the association asking the board to provide books and records. So this is one of those, I'll give you the rundown of how the books and records access works. And if you're an incorporated association, it's in Title 18, Section 1065. Section 1069 gives a form of records, but that's not going to be really helpful to your associations in terms of, okay, this is exactly what they need to look like. Section 521 is for the condo association. And where I say none for HOA, that simply means that RETA, the Real Estate Development Act, if you remember back Title 60, Section 851, it doesn't say anything about association books and records. So a lot of times what we're doing is relying on the governing documents. What do the covenants say as far as books and records access? What do the bylaws say? Okay. In section 1065, there's language about making a request and having a proper purpose. Courts interpret this proper purpose as just about anything. So if the association gets a records request that says, I want to see the books and records because I think y'all have been embezzling and I want to figure out a way to throw all of y'all out because I think you're terrible. That's a proper purpose, okay? Maybe not a legitimate or even a reasonable purpose, but under the statute, it's going to be a proper purpose. What would not be a proper purpose is someone who is a renter asking to see the books and records. Renter is not a member of the association. Occupants are not members. Lot owners, condo unit owners, those are members, and those have records inspection rights. It is entirely possible that someone is asking for the books and records because they have a good faith question, because they have a curiosity that they want satisfied, they have a legitimate concern that they want quelled. It is possible, right? It is also possible that someone's making a books and records request because they've been told no, because they have had an enforcement action filed or brought against them. They received a demand letter. I see this pretty frequently where the records request is basically oh, you want me to do something? Well, now I'm going to make you jump through hoops, okay? The fact that we suspect that someone is making a bad faith books and records request is not grounds for denying the request. It is sometimes grounds for making sure that we are careful with our language, particularly board members in emails, in text messages, in social media. Of course, as board members, we're never going to name call. We're never going to cast aspersions. Certainly not going to do anything that we wouldn't want a judge to see as an exhibit or a jury to see blown up in very large words. We don't ever put that stuff in writing, of course. But we also want our words to be helpful, our communications to demonstrate customer service, or at least a willingness for customer service. So I'll kind of give a hypothetical. This is generally how these come in. Email goes to the board or to the manager. Hey, I want to see this, and this, and why did the board do this, and why can't we do this? A lot of times the records request is interspersed with a bunch of questions. Well, the board is not required to answer every question that comes to a member's mind, particularly not at midnight when they're firing off emails or posting next door questions or Facebook messages. That's not the board's responsibility. And the board sometimes has to exercise restraint and discipline not to immediately fire back and answer. And so when someone posts something on Nextdoor or Facebook, immediately after they have sent an email to the association board or manager asking for the books and records and goes online and says, I've asked the board and manager for copies of the books and records. They haven't provided them to me. What are they hiding, right? I mean, that's how sometimes these things go. The inclination, the motivation is to hop on. What are you talking about? We got your email 30 seconds ago. Why are you doing this? We're open. You get defensive. You don't have to do that. You don't have to answer every question that comes to people's mind. And you don't have to think that you need to go online and set the record straight from every crazy thing that comes out of somebody's mouth or keyboard. I know there's a feeling that, well, we have to set this right or we have to defend ourselves. No, I mean, there's people saying things on Facebook right now, possibly about me, that I disagree with. I know it's shocking. There's people out there typing things that we disagree with. but we don't have to address it, right? We do have to address books and records requests that come in. And if a person is doing it in a means to harass, well, then one technique we have is, look, 1065 isn't a you demand and we provide you copies. It is giving you an opportunity to inspect and copy. So we're going to prepare a place where you can come and we will give you sticky notes, or you're free to bring your own sticky notes. And we will make all the books and records available to you. You identify which ones you want copies of. We'll figure out how much it's going to cost to copy those. You pay us that amount, and then we'll provide you the copies. So if someone wants to make the board or manager jump through hoops, then they can't do it just by demand. They're going to have to participate. Now, if what they're wanting is a copy of the 2021 budget because they want to compare it to the 2022 budget that just came out, print it off and send it to them. I mean, that's a customer service thing. There's really no reason in the world to make them jump through a hoop. And a lot of these records are going to be online anyway, and we can streamline the process. Someone comes and says, hey, I want to see this, and this. I want to see a balance sheet, profit and loss. Not a problem. Use your login. They're all online. Or, hey, I need a set of covenants for my section to see if I can do this, and this. Not a problem. They're online right here. Have at it. We can streamline and kind of anticipate a lot of those questions and put those records online. Okay. So that's books and records. Georgie, any of those questions, or I can cover some of these things that I hear that I want to make sure we don't believe.
I was talking away and I was on mute. I've definitely got some good questions. You ready?
I'm ready.
Okay. Does it meet notice requirement to just put signs in the neighborhood's entry for the annual meeting?
Possibly. So this is a question that we would look to bylaws to answer. And it is entirely possible that the bylaws say posting signs at the entrances to the neighborhood is adequate notice. It is possible. But I mean, without looking at the bylaws, I can't tell you whether it is for your neighborhood or not.
Okay, so they need to look at their bylaws and see what it
Yes.
says. Okay.
Yep.
Can we publish the names of the homeowners who have not paid their dues in our newsletter?
This is a really common question. Do you remember some of us of a certain age? I won't specify the age, but do you remember going to stores and there would be the list of shame next to the register? And it was right there where you could see it, or it was posted on the wall for everyone. I mean, it was the modern equivalent of the public stocks, you know, where you could throw eggs and tomatoes at people.
You're talking about the bad checklist, right?
That's right. Yeah.
Yes.
If you notice, you don't see those lists anymore. And there's a really good reason. It's because of defamation. So the answer to the question, can we post the names of delinquent owners? You certainly can do so. And I can almost guarantee at some point the association and possibly individual board members will be sued for defamation. There is no good reason to do that. There are a whole handful of reasons, bad reasons, to post them. And so it's a horrible idea. Anytime we're looking at browbeating or public shaming, those kinds of techniques, we have to be very wary of what possibly comes back. I mean, this is kind of, in my view, those tactics are like filing litigation to get somebody's attention. You know, just you don't use it that way. That's an improper reason to file a lawsuit, is just to make a point. So what you can do instead of publishing delinquent owners is thanking the owners who have paid, not specifically identifying, but thanking them in newsletters, giving percentage. So that's been shown to be pretty effective, is showing in a bar graph or a percentage of how many of the owners have paid, and encouraging those who haven't to join their neighbors and fully fund the association. So that's, and getting back to records requests, oftentimes, so if our firm does a lot of debt collection for condos and homeowners associations. And so it's not uncommon, we'll send a collection letter to a debtor, and what comes back is a books and records request. They want to see all this stuff, including who else is delinquent. Well, we're not going to provide that information. The association is not going to provide that information. We can refer you to the public records for all the liens that have been filed, the public court records of all the court cases that have been filed. And if you're really, really interested, we can give you a percentage of who all has paid, leaving the percentage who hasn't, but we're never going to give you the names of the people who are not current.
Okay, we've got about 4 more questions at least to get through in about 5 minutes. So we've got, don't have much time. Does penalty language have to be in the covenants, or can it be in the bylaws?
So we covered this. If the answer is always in the covenants, okay? And it has to be clear, organized, organic, meaning it gives broad enough notice, and it's clear enough that this is what we're talking about, monetary penalties, not some general damages sums. It can be in bylaws, but the bylaws have to be recorded. It can be in covenant bylaws, or in condo bylaws, because condo bylaws are always recorded. So there's not a quick, okay, we're going to get monetary penalties because we're going to stick them in corporate bylaws, because boards can unilaterally amend bylaws. Members can amend bylaws, but that's not good enough. If we're going to take money from people, if we're going to file liens against people's property, it's got to be in the real property covenants recorded, or in a recorded set of bylaws.
Okay. When covenants allow for penalties in general, can the board then set the dollar amount for each penalty, each fine that they're going to fine?
Ideally, the covenant language authorizing monetary penalties is going to answer that for us. There should be language that tells us, okay, who adopts the fine schedule? What are the fines attributable to? Is it just fines relating to common area rules? Can the fines be applied to uses or behaviors on a lot? I mean, the idea that monetary penalties can be vague in general, it needs to be wiped out of our concept of monetary penalties. And so typically a board will adopt the fine schedule, but that's only because that's what the covenant tells us who adopts the fine schedule.
Okay. If someone requests a list of late dues, if a member requests a list of who's late on their dues, can you give that to a member?
You can, but again, this is kind of like posting the names of the delinquent owners. there are a bunch of really bad reasons why you would do that, particularly being sued for defamation. So, I mean, the problem with that is my name is on the delinquent list because I lost the invoice. I remembered yesterday, oh man, I forgot to pay my dues. And so I have cut a check. That check is sitting in the association's mailbox on day 3, but on day 2, you handed a list to, so-and-so, and my name's on it. Well, I'm not delinquent. I've paid my dues. You just haven't gotten my check yet. And now you've got this person who knows what they do with it. And so there's no good reason to do it.
How long do you need to keep records?
So this depends on the record that we're talking about. If they are corporate minutes, if they are governing documents, if they're corporate resolutions, the answer is forever. Those are forever part of the corporate memory and record. I have a case in an Oklahoma county right now. This association has been incorporated since the early 70s. And an issue after 50 years, somebody pops up and questions something fundamental. And we have gone back through all of the meeting minutes for 50 years, and they had them, which is astounding. And again, those meeting minutes are the prima facie record of what the developer did way back in the 70s and what the very first board did when the developer handed it over and answers this question for us. So always keep meeting minutes, have a good, an accurate, good set of governing documents, meaning not a set of covenants that somebody's retyped and that we think are covenants. We want covenants that have been recorded. Those are the ones that we can rely on. We want a clean set of bylaws and articles of incorporation. Things like tax returns, contracts, profit and loss statements, 5 years, 7 years, something like that. Typically 7 years is the longest we're going to keep those kinds of records.
So most people aren't going to keep minutes for 50 years, like your example. So how long should they keep minutes?
They should keep them forever.
Really? Okay.
Absolutely, yes.
All right.
For the attorney who's litigating that case, I would be scrambling if this association only had 5 years of minutes. I would have a very difficult time. It would be much more expensive for this association because what I'd be doing if I didn't have the meeting minutes, I would have to rely on testimony. And I would be going back 50 years and tracking down people from the original development company, if they were still alive. If those people are in their 40s then, they'd be in their 90s now. And,
And it's okay for them to scan them, then put them on disk now?
Absolutely. In fact,
okay.
Almost all of the association records should be scanned and be in digital format. That's one of the ways to really streamline records requests is, so our firm uses Citrix. I know a lot of people use Dropbox. Google has their service. You can organize all these in folders where you have the general access folders. Then you could have some of the, if you had employment files or attorney-client privilege or the delinquency folders, you could exclude those. You can make all of these records available to members just with a click. And it really takes the headache out of records requests.
Okay, one last question, and then the other questions we'll be able to get to on Thursday night when we come back. Okay. There is a question about short-term rentals. The first line of the slide that you had said that the home must be the primary residence of the owner. What if the primary residence is it is not the primary residence of the owner? Do they still have to meet the requirements that the city set?
Yes, so in order to qualify in Oklahoma City for that business license, it has to be the owner's primary residence.
But what if it's not their primary residence? So, but
Then
they can still do Airbnb, short-term rentals?
So those people are either going to lie on the application and say it is their primary residence, or they're going to operate an Airbnb in Oklahoma City, where the ordinance says if you're going to operate an Airbnb, you have to have a business license.
Okay. All right. So there we have it. So in Oklahoma City, it must be your primary residence. So you can use that. You can go back to your, if you have one in your neighborhood, the person who asked that question, and let them know that they're doing it illegally. You can turn that into the city of Oklahoma City and let them know that that's not their primary residence. Okay, very good. We want to thank Matthew for doing a wonderful job tonight, which he's going to do another wonderful job on Thursday night. We did this to 2 nights in 1 week this time. First time we've done this, rather than doing it for 2 different one night for 2 different weeks. So we will see you all again on Thursday night, same back channel, and we'll have another wonderful evening of getting together and learning a lot of good things about your neighborhoods. In the meantime, let us know if you have any questions. Don't hesitate to send them to anybody on our staff. Send us an email, and we'll be glad to help you out from there if we can. Don't forget that Neighborhood Alliance is here for you, for your neighborhood issues and neighborhood questions. So let us know what we can do for you. We will also send you an email letting you know how you can donate to Neighborhood Alliance. So if you like these kinds of workshops and you think they're helpful for you as an individual and you as a neighborhood, please think about donating to Neighborhood Alliance so we can continue to be there for you. Thank you very much for coming, and enjoy your evening. Bye-bye.
Bye, Georgie.